Welcome to the show Real Estate Matters. I'm your host, Brett Furman, and for 35 years, I've been helping the community write the real estate success story as broker and owner of Remax Classic. Today, joining us via Zoom during the COVID-19 pandemic is special guest Joe O'Brien. Joe is a partner of the law firm KAO Law Associates, and today we'll be speaking to him about the countywide reassessment and tax appeals in Delaware County. Thanks for joining us, Joe. Say hello to everybody.
Hello, everybody. Sorry to be taxing your ways, so to speak, but ironically, our law firm has been doing this for 32 years, and we have been through Delaware County's last reassessment, which was 1998 for the year 2000, Chester County, Montgomery County, 96 for 98, Lehigh County, I think it was 2 or 3 years ago, Lancaster County. So there's a lot of reassessing, and you might say why. And the reason is that hidden in the Pennsylvania Constitution is a provision that says that all taxes are supposed to be uniform on the same things. And on real estate, that basically means that if you have a property worth $100,000 in a particular taxing area, you should say the same taxes, in effect, as a property in the same district down the street that's worth $100,000. And as time goes by, appreciation, neighbors change, and so on. So you get to a point where a court will enter in 2017, now retired Judge Charles Burr from Radnor, the Delaware County judge, ordered a countywide reassessment. Judge Labrum, back in 1998, had ordered the same thing in Delaware County. Not something that local officials want to do because basically, in my humble opinion, and I have a lot of humble opinions, have been doing this for, as I said, since 1988. And most residential property is underassessed. So you're not going to find many people who are going to call you and say, I don't think I'm paying enough. I'm not paying my fair share. And, I tell them, well, as a public service, you should turn yourself in. That's when they hang up.
Yeah.
So now you come to most residential property. And then you have the situation of commercial industrial investment property, which frankly is where we work on a contingent fee of a percentage of savings. So there's more savings with more zeros, so to speak. And the other thing is that commercial investment industrial property doesn't vote. So they can't come to a school board meeting and say, what are you doing? How come you're doing this or that, or complain? So that's just sort of the background of where we are. Pennsylvania has 67 counties, and in each county, I think we have 13 school districts in Delaware County, just in Delaware County, and I'm not even sure how many cities. Well, there's only one city, Chester, but boroughs and townships. Each one has its own tax millage that they have to set each year, and each school district does. So if you have a property in Radnor Township, you're going to pay Delaware County tax, you're going to pay Radnor Township tax, and Radnor is one of the, I think, only two school districts where it's only one municipality. I think Haverford is the other. Most, like Upper Darby, includes Clifton Heights and Millbourne. Rose Tree Media is Upper Providence Media, Middletown, and Aston is Aston, Parkside, and Brookhaven. So, and it goes across the board. So every place has a different rate. And that's where it gets confusing too, because the tax rate that you pay in Radnor on, say, $100,000 is the county, township, and school millage. But if you were in Colwyn Borough, that's the same county, different school district, different borough millage. And so the $100,000 in value, and I understand that with, different location, but with $100,000 in one part of Delaware County could sometimes pay 3 times what you pay in another part. Thornbury Township, Delaware County pays about 1.2% in tax, and you get into the river boroughs and townships closer to the river, and they're paying close to 4%. So that's 40,000 per million in one of those municipalities versus 12,000. If you look on my website, the law firm's website, we'll give it www.kaolawassociates.com. We have extensive, boring, but full discussion of all this stuff, as well as a copy of what we call the effective tax rates, and showing that, for example, what $1 million of property would have paid in 2020 in Upper Darby versus the other. Now,
different.
What? I'm sorry. So to get to the, what's the assessment? Well, basically, in 1998, Delaware County reassessed, put a new assessment on every property. And I think there's over 200,000 tax parcels. And the predecessor company of Tyler, which used to be called CLT, does most of this. And I'm not quite sure. I think the cost is about $6 or $7 million, but it's not cheap.
What does that equate to per property, do you think?
Well, I guess if you divided it by 200,000 and you divided it by 20 years, it's not a lot. Okay. Well, I mean, everything's a lot, but that's about what they did. The same. They did the reval in Chester County, Montgomery County, Lancaster, Lehigh, I'm pretty sure. And they are it's actually an Ohio company, and they're you notice when we go to all of the counties, but mostly, let's say we stick to the east coast of Pennsylvania, okay, not too much west coast stuff, right, and every county is different. So and every county has a different ratio of assessment, and that's where this is what happens. In 1998. There hadn't been a reassessment for, I don't know, 30 or 40 years. Nobody wants, as I explained, nobody wants to have their name on the letter saying, we caught you at last, right? So it was the ratio of assessment in Delco in 98 was 3.3%. Okay. That meant that a $100,000 property had a $3,300 assessment. And everybody, they would look at their low assessment and think, well, they didn't know that you had to divide that by 0.033, which meant that $3,300 equaled 100,000.
Do you think, Joe, that that's intentional and to keep it so that the average person can't figure out what this is all about?
Well, not with the recent spate of lawsuits, which forces them. Remember, it was down to 3.3% before it was ordered up to 100% in 2000. It was only down to 56.4%. I mean, we were actually higher. Montgomery County, I think it's 46%. Bucks County, get this, Bucks County hasn't had a reval since 1972, and their rate hovers around 9%. Okay. So a person calls you up with $1 million assessment. They say, boy, I'm really assessed low. I'm only assessed for $1 million. And they say, well, that's really $10 million. And they don't get that. But nobody has been successful in Bucks in getting a court order. The significance of the percentage is that as the years go by, if you want to figure out what you're being valued at, so let's assume that you will take the $100,000 property. Okay. And if you have an assessment of $56,400. All right. Now, I picked that number because the common level ratio for Delaware County was last year 56.4%. So if you divide 56.4% into $56,400, you got $100,000. So then you have to say to yourself, would I sell this property for more or less than $100,000? And usually, the calls we get on the smaller residential properties, oh no, my property's worth $200,000. Then I give them the joke about turning themselves in, and they hang up. So in Delaware County, the judge ordered in 2017, excuse me, I think the ratio was actually more like 61%.
Okay.
See, the ratio, the common level ratio, changes every year for every county. So in 2018, the sales of 2018 were accumulated by it used to be called the State Tax Equalization Board in Harrisburg,
okay,
for every county. And then they would figure out what did the properties sell for and what were they assessed at. That ratio would just be, and that could be a property on the river that sold for $1 million with a $100,000 assessment, and a property in Radnor that sold for $1 million with a $90,000 or 900. So they average them, and it's a little complicated, but basically, when you do this over the years with all those different points, that ratio ends up getting a rise, so that you have a lot of properties that end up having an assessment that's a lot lower than the ratio, and that's when a court will order the reval. So what happened in Delco is when they sent the notice out July 1st to all over 200,000 properties, that heck of a mailing bill of this year, they said, this is your new assessment. They didn't say, and I think they should have said, is your old assessment was supposedly 56.4% of value. So if you had the $56,400 assessment in my example, and you got a letter that said, we think that we're going to assess you at 100% of, they're saying July 19, which is $100,000, right? Well, most people thought, my assessment got doubled, so, oh my God, my taxes are going to double. Well, the reality is that in an awful lot of residential situations we've seen and talked to, when we tell the people, okay, your old assessment is 150,000 and your new assessment is, let's say, 250.
Okay.
Divide your old assessment by 56.4, or you multiply it 1.17. The bottom line is it comes out that you were assessed for more, not less. Before you were probably
the prior one.
Assessed, yeah, and or you were underassessed. And the joke among people like me who do this work is the most common complaint is, how come I'm not as underassessed as I used to be, or how come I'm not as underassessed as my neighbor? And so there's only so much you can do. We concentrate on the $10 million plant that should be valued at $5 million, obviously. But
so, Joe, that goes back to, they're looking at a value of July of 19.
Right.
What about in like COVID, where you have a hotel or you have a retail center where all of a sudden you have, 5% occupancy of your retail tenant, and your hotel with, 200 rooms is generating, there's 10 rooms being occupied. Is there any provision?
Well, there's a couple of issues here. First of all, the county in its notice, the 200,000 letters, said this is your July 1st, 2019 base year value. Okay. Now, the assessment law, and basically there's one assessment law for all the counties except Philadelphia and Allegheny, which is Pittsburgh. Okay, we won't go there. I mean, it's similar, but the new statute only started in 2011, and the other one was, I think, Abraham Lincoln. So, but they get to the same result. And so the statute says when you file an appeal, the value on the date you file the appeal should be the assessment for the following year. Okay, so most appeals are going to be filed on or before September 1, 2020. that incidentally, that the statute says it should have been filed 40 days after you got the notice. And because of COVID, the court
They
entered
extended
an
it.
order
Okay.
extending it to
Yeah.
September 1. And as a lawyer, I don't know 100% that even that's valid. I don't think there's an authority to do that, but whatever. So we're going to follow that. So then the question is, what's the valuation date? Well, obviously, the first question is there a difference in value between July of 19
Yes.
and July of 20 for all property? Now, residentially, I had this discussion with a colleague earlier today, and I said a lot of the realtors are telling me the market is hot for residential, so maybe there isn't that much of a difference. And he didn't seem to agree with that. I don't think there've been many sales, but the question is, if you could value the property on the date of the filing the appeal, which is, let's say, September 1st of 20, and it's lower, why can't you use that? I have a legal disagreement with the solicitor of the Delaware County Board of Assessment. She, very nice person, used to be the solicitor for Montgomery County when they did their reval in 96 for 98. So, but lawyers don't always agree. I think the statute says you get to use the date of the filing of the appeal. So that's a general proposition. And for residential property, does it make a difference or not? Okay, and that's because what if it turns out it's more on July of 20 than July of 19? Then I'd say, oh, I like July of 19 because I'm an advocate, right? But now let's get to the commercial and the hospitality property. You know, the hotel that had 80% occupancy last July, and now it's got 10% or nothing.
Yes.
Right. So just using that as the difference in the two valuation dates, it's going to be a legal battle over which one you can use. Now, keep in mind that you're arguing about next year's assessment. So
2021 is when it kicks in.
Pardon me?
It kicks in 2021.
Well, it's actually the calendar year of 2021 for the municipality and the county, but it's the July 1, 2021 to June 30 school year for all the school districts.
Fiscal.
So you know, and it makes a difference again depending. Now, so you have that issue of which valuation date to use generally. Now, there is a special provision that called a catastrophic loss provision, which is usually aimed at fire, flood, you know, physical damage to a property. If there's more than a 50% drop in value from before the catastrophic event, then and you file within 6 months or within a certain period of time after the end of the year from when the event happened, you can get it reduced as of the date of the catastrophic loss. So if the governor proclaimed on March 18th, 2020, Governor Wolf, that businesses were closed. Now, first of all, what's the date? Secondly, is there a physical event? And I guarantee you that every school board lawyer is going to say, no way, because this is what happens. And of course, thirdly, you have to prove a 50% drop, which is you know, appraisers can, with their formulas, can do this and that. If it isn't at least 50% drop, then it doesn't qualify as a catastrophic loss. Then you get into the question of, okay, it's only a 40% drop, which means it's worth 60%. Well, can I use that for next year, or can I use the prior year, which sticks me? And so that's the issue on the catastrophic loss. Now, the argument that a lot of lawyers are making with business interruption insurance, but you know, suddenly if you had a fire, and you know what, business interruption insurance, maybe it gives you a gross revenue to pay rent, utilities, et cetera. Well, the insurance companies are all, you know, they don't want to pay it. But the argument that's being made is that the virus from the pandemic, remember, one of the reasons that they're closing places down is that it can physically attach to the parts of the building, the tables, the rooms, the doors, the handles. Is that enough of a physical connection to justify? I mean, it's not a lightning bolt, it's not a flood, it's not a fire. I would argue that it is, and I guarantee you that there's going to be strong argument that it isn't. But I'm going to raise it in every property like that. Now, I've got to get an appraiser, a legitimate appraiser, who's going to be able to opine that the value did drop. And then I still have to prove the physical connection. So it's an uphill battle, but I can't ignore it.
But
And
Joe,
then,
is that a one-time, one event type thing, or you have to do this individually for each property, or is there anything that could make it more of a class type of a thing where it would apply once you have one ruling would apply to everyone?
well, if you had 100 condominiums in a development and they all burned down, I think you might. There's special rules about class actions, and they don't want it to be too easy. I won a class action about 20 years ago, and the county had improperly assessed 1,700 properties in other Providence Township, and we got the county to pay back $3 million. But those cases don't happen too often, and would it, as a general proposition, I would say no. The other thing is that if you think about a hotel, I think a hotel would be suffering a lot more from the pandemic than an apartment building. People might be slow paying, but I don't think you're going to go from 80% to 10% occupancy.
Right. Didn't happen.
Which and you'd have to justify the 50% drop. It's an uphill battle. And the other thing I mentioned to you about the common level ratio, as I said, it's different for every county. And so the state accumulates this data and they come up with this average. Well, in June of 2020, they said that the average of the data from 2019,
right,
because it was the sales in 19, they take 6 months to accumulate it. They announce it by July 1st of 20, and normally it would apply to the 2021 tax year unless you're having a countywide reval. So that's how that number every year changes. That same number is used. You've probably done situations where there's a no consideration deed, but it's still taxable. They value the property by taking the common level ratio. They convert the ratio to a multiplication factor. If you divide 1 by 56.4, you get 1.17. So if you multiply the assessment times that, that's the transfer tax you would pay. And that goes into effect. That's even in effect in July 1st. So, but it has nothing to do with this. So in terms of the common level ratio, then the other thing is, I mentioned before, when the assessment is raised to 100%, the statute requires that you reduce the tax millage so that the municipality, county, or school district doesn't, obviously, if you almost double assessments and keep the same tax rate, you're going to double money. So you have to lower so that the money you collect isn't any greater than the money you collected the previous year. And there's a mechanism where they can get it up to an extra 10% with a special separate hearing of the municipality. So when your assessment went from 56.4 to 100%, well, then that tax rate, the tax millage, would have to go down. The millages in most counties in Pennsylvania, 80%, 75 to 85% of the tax millage goes to the school district.
Got it.
And about 10% goes to the township or borough, and 10% goes to the county. So the reality is, when you're fighting about this, even though it's a county board of assessment, the decisions in most counties are really made by the school board solicitor at the direction of the school board. So they're paying their school board lawyer to try the case against you. Okay. They're going to pay 80% of the cost of their appraiser. So they have the most to win or to lose. And that's where now there's another thing to mention, which is that, we talk about filing the appeal has to be filed by September 1st.
First deadline.
But just this year, it's August 1st. The annual appeal is August 1st for all the other counties except Philadelphia and Pittsburgh. Philadelphia is the first Monday of October, and Allegheny is already past March 31st of this year. And they said, but since it falls on August 1st falls on a Saturday, it carries over to Monday, so August 3rd. And I'm saying that because it's only, a week and a half away, and people may have properties in both counties. And the rules, the common level ratio, it's in Chester and Montgomery County, the ratio is almost exactly the same, just by coincidence, about 46%, or it was 49 for 46%. So your assessment doesn't mean that's what you're being taxed at. But if you divide your assessment by the ratio, you may find out that the value, it's called the implied value, is actually a lot more, which you should appeal, or it's a lot less, which you should sit on your hands and thank God. So I don't know what else.
Well, Joe, I think that's a good spot to wrap up. I'm very appreciative to have you, and I want to thank everyone for tuning in today, and for my special guest, Joe O'Brien. Once again, I'm your host, Brett Furman. For more information, or to get a copy of a free book I wrote, What You Really Need to Know About Selling Your Home, you can visit my website at www.brettfurman.com. To visit Joe O'Brien, you could visit his website at www.kaolawassociates.com. Joe, thank you very much. I really thought that this was a great, very topical one for today.
Well, it's going to be, there's 200,000 properties, and we estimate that if 5% appeal, that's 10,000 appeals. They have to be done by October 31st. So the virtual appeals, the phone appeals, I don't think they're going to be finished.
Okay. Well, thank you, everyone. Stay safe out there, and join in next time. We'll have another guest on Real Estate Matters. And I'm your host, Brett Furman. Thank you.
Thank you.